Alex here with part 212 of the My Docket series on child custody and visitation. As my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen this yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my external rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go into my motion for costs on appeal. This is me trying to recover the other costs that I mentioned in the last video that are not allowed to be taxed in the Supreme Court. These costs are allowed to be taxed in the lower court. One thing I wanted to talk about, guys, really quickly is the issue of running ads on videos. I was going to do this as its own separate dedicated video, but I don't think that's really, it's kind of a silly video to publish. So really quickly, we got a new email, all of us. YouTube creators got an email from YouTube, and it states that from now on, they will put ads on all videos, even if we tell them not to. The only difference is that if we tell them not to, they will keep all of the money, and if we tell them to, then they will divert money to us. And I think it's really silly. I think that that's one of the things that we can kind of give to our viewers, but they've taken that away. I'm not going to complain because YouTube does still fund both the proper person and our Nevada judges, and it helps a lot. But I did want to at least let you guys know why I stopped the practice of cutting mid-rolls from the videos, because YouTube's going to put them in there anyway, and they're just going to collect all of the revenue from it. So at least this way, it's a way for both myself and our Nevada judges, I guess if you want to treat it separately, to get revenue to continue to fund stuff. So let's go on now into this specific video's mindset. My mindset was positive because I felt like, hey, not only did I stop my ex from getting $1,700 in attorney fees that she did not deserve, but now I can get back the costs that I had to pay when I filed that appeal. And that's how you make someone whole. Somebody has to go through all this work to fix a mistake that the judge made. The very least that the judge can do is actually fix that mistake completely. That's not what she did. This judge is not going to grant this motion, which is going to lead to another appeal, which is going to lead to another order reversing. After the second screw up, she gets it and she stops screwing up. But we'll talk about all of that when we actually get through that part of the process. For now, you're going to see me ask the court for costs, which I'm entitled to under the law, which is clear, which the Supreme Court and Court of Appeals will have to once again intervene on. But I do remember that at this time, I felt very positive. I felt like I was going to get my cost award because I naively thought that the court was going to follow the law. And, you know, I know why they didn't. If I had an attorney and they filed this, it would be granted. I very strongly believe that that would have occurred. Not having an attorney, I believe we have an example of self-representation bias. Please watch my video on the topic self-representation bias and meta rulings, which is that the court's thinking, well, since you didn't have to pay a lawyer, at least you can pay the court. I mean, an attorney would have cost you thousands of dollars. You did this for yourself for free, so you can at least pay $250. And also possibly that the judge felt bad for my ex, which once again is bizarre, since they're the ones that were able to obtain something that they should not have obtained. You can see that I have a lot of contempt for this because I do very strongly believe, I'm not just trying to bash the judge, I do very strongly believe that had I had an attorney, this motion would have been granted, which leads me to the ugly conclusion that because I didn't have an attorney, the motion was denied, which is not a good thing for the American justice system. You know, they complain about how people think that only rich people get justice. And the thing is, only rich people can afford attorneys. And so if you have all of this self-representation bias against people who are poor, who can't afford counsel, how are you going to complain when people then turn around and say, hey, our justice system only works for the rich? It's like the judges, I'm not sure that they realize it. They just kind of, without thinking, I think, accidentally end up furthering these really bad things that ordinary people are coming, these bad conclusions that ordinary people are coming to. Again, guys, there are a lot more details in my videos on the topic self-representation bias and meta rulings. Definitely watch those videos if you haven't seen them yet, because it's not just that the judges are evil. I think that in those videos, I articulate all of the different things that kind of go through their minds as to why they make these decisions that are damaging to the judiciary. All of that being said, let's go ahead and take a look at what I have filed. Here we have the motion for costs and return of cost bond. Standard introductory paragraph. I introduce myself to the court as the petitioner. I indicate that I'm appearing a proper person, which means I don't have an attorney, and that I am filing a motion for costs. The motion is based upon the following memorandum of points and authorities. Not very long motion, guys. First paragraph is that this court committed reversible error in awarding attorney fees to my ex. And then I cite the Court of Appeals order reversing and remanding. The duty of taxing costs is bifurcated between the Supreme Court of Nevada, Rule 39 sub C1, and this court, Rule 39 sub E. This court has no discretion, and the statute is 18.060, and we have a case. And I want you guys to remember this when the judge flagrantly violates the law. Kiever v. Jewelry Mountain Mines Incorporated. This is the Supreme Court of Nevada stating, quote, in construing the law, we have held that its mandatory requirement of awarding of costs is clear, emphatic, and peremptory, unquote. Clear, emphatic, and peremptory. And she doesn't do it. She just denies it. And then guess what the Court of Appeals says? They regurgitate the statement that they already made back in 1986. Again, just a reminder that the awarding of costs is clear, emphatic, and peremptory. I think people really don't understand this disturbing issue that we have in this country where we pass statutes and judges ignore them. Why go through all of the work as a society to debate and debate and debate and argue, and then you pass a statute and then the judge just says, nah, I'm not going to do that. I don't know how much more clear you can get from clear, emphatic, and peremptory. I don't know what else you can do to really explain to them that this is not a statute that is optional. We're going to go through the entire train wreck. This case is not over. Anyway, let's keep going. I filed a verified memorandum of costs. The losing party is never entitled to costs. I posted a cost bond with this court. I'm wanting the court to direct the clerk of the court to return the entire bond to me forthwith. And I am requesting that this court impose an award of costs in the amount of $250 in favor of me and against my ex. And that this court direct the clerk of the court to return the $500 cost bond to me. Rule 5, certificate of service indicating this document was mailed to my ex. Memorandum of costs. We have another bill of costs, and this is for the filing fee of the notice of appeal, and that's $250. Next, we have the clerk's judgment. The clerk's certificate, and the Supreme Court clerk has issued a judgment against my ex. Of course, it's just for peanuts. I think it's like $5 or $6 in copy costs. But the big amount is going to happen from this lower court judge after she gets ordered to do so again. Next, we have the memorandum of costs. This is what came from the Supreme Court. And that's it there. Next, we have the request for submission. And here I am submitting to the court for a decision the motion for costs that I just filed. And I'm asking the court to merge the costs that I'm requesting with the costs awarded by the Supreme Court of Nevada. If you want to learn more about the request for submission, guys, please watch my video on the topic, request for submission. Rule 5, certificate of service indicating this document was mailed to my ex. I don't know why it's not signed. This ordinarily would get rejected. Actually, that's why there's another one, I think. Then maybe this one is signed. Yeah, this one is signed. Okay, so they filed both of those, and this is the signed one. I don't know why the other one was filed. They should have just rejected it or marked it filed an error. Doesn't matter though, because I corrected it and I filed it with a signature. Again, guys, watch my video on the topic, request for submission, if you'd like to learn more about how those work. Going into the aftermath, I filed, let's see here, 1, 2, 3, 4, 5 documents. They were all free filings, so I incurred $0 in costs. My ex didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex didn't have an attorney, so she incurred $0 in attorney fees as well. As my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.